We'll wait for Mr. King. Go ahead and take a seat. Sure. Gentlemen, would you like to identify yourself? I'm sorry, I don't need to interview.
Yes, I'm Clive King, and I'm here to discuss the capitalization fee tonight that was imposed on the transaction, and would like to discuss the reasonableness of the fee. And this is Chuck Curran.
My name is Charles Curran. I'm an attorney in Fairfax, Virginia. I represent Mr. King.
Well, Mr. King, would you like to make a presentation of your appeal?
Well, yes, please.
Let me speak for Mr. King. Members of the board, thanks for hearing us. It took us a while to get out here. We had a couple obstacles on the way, but thanks for letting us in. As you might know, Mr. King was the owner of the property in his community for a while, acquired title from a company, SRA Capital, in January 2007. It's now defunct. It's a long story. I won't bore you with it. It's a matter of a fraudulent scheme that's the subject of a lawsuit in the circuit court in Frederick County, Winchester, involving the former owners of the property, the delays, and Mr. King and a guy by the name of John Partridge, who is the one who we believe caused all these things. In any event, Mr. Partridge had set up a company, offered investment opportunity to Mr. King, agreed by contract to sell the property here in Lake Holiday to him. Did that, but in the form of two deeds that were recorded virtually back-to-back on the same day. I think it was January 12th, 2007. And in one of those closings, it was also Mr. Partridge's wife's title company that handled the transaction. The $2,000 fee was in fact collected and paid to your association. Sometime later, and after this notice of the suit was served on Mr. King, which we are now defending, we received a notice, or he received a notice from your association that you wanted another $2,000 capitalization fee for the fact that there was a second deed on record. We don't know how long, but perhaps 30 minutes, something like that. So that's the basis of the appeal. And the basis of the appeal really is on two levels. One is on a practical fairness level, if you will. We think that it is patently unfair that for the fact that the transaction, fraudulent transaction, that was structured in the way that it was, that resulted in two deeds instead of one, and had absolutely no effect on the use of Lake Holiday, any of its facilities, any of its rights. No one acquired any use to go through the gatehouse or use your roads or common facilities or anything. Should be taxed twice with that $2,000 fee instead of one. That's the equitable argument. There was no additional cost to your association at all. And it seems to me that it is an overreaching and overly technical, as I said, frankly, unfair result to impose this $2,000 fee on Mr. King, or to attempt to. The property was ultimately sold to some other folks who I believe now own the property, and I understand they paid their $2,000 fee, and that was a month or perhaps a little bit more ago. So that's really the essence of what we wanted to say, and that's why the appeal is put to you, to say, please relieve Mr. King of this unfair burden of the additional $2,000. It's not related to any costs that were imposed on your association or on the community. Having said that, though, I think that there are also some legal reasons, and it's not my point to try to lecture, really argue with you or anything. I'm sure you have your own counsel, but there is a requirement in the Virginia Code. I brought that volume with me if you want to see it. It's 55-514 that talks about special assessments. I'm not sure how this $2,000 would be characterized. Certainly, it's not ordinary assessments and dues. It would seem that it's in the nature of a special assessment, but it's not a traditional special assessment where you're going to replace some capital infrastructure of the community. But that section requires a finding by the board that the assessment, such as it is in the best interest of the community. And with the information that we've been able to obtain from your website, the capitalization fee was last discussed and the subject of a resolution of this board on November 27 of 2006. And that change was to go into effect on January 1. And that resolution does not contain the necessary statutory finding. So I would suggest to you that in that respect that it is deficient. There's not a finding by the board that it's in the best interest of the community. And it has to be, I would suggest, also pretty specific and not just assumed. And also there's something else in there that this resolution goes on and not on point directly with our appeal, but it's a part of the same resolution, so I think it's important that you know about it and consider it. And that is, number 5 says that the capitalization fee will not be assessed when the property is transferred to a family member, and then it contains a definition of what family member is for the purposes of the resolution. That does not comport with the statutory definition of family member, for which there's an exception in the Property Owners Association Act, which talks about anyone of lineal consanguinity. So if you're of the same blood by definition in the statute, you're the same family. What I'm telling you is that there's really another deficient provision, unintentional I'm sure, but there's another provision that may cause you problems when you have other transfers to consider among family members. Nevertheless, it's contained in the resolution that is the most recent resolution that has continued this capitalization fee in effect. Lastly, to my knowledge, and you can correct me if you're wrong, the statute also requires that in order to perfect a lien, that a lien be filed within a year of the time that it would become due. And if that was the case, if it was in fact due, and of course I've suggested that it's not, principally for the fairness reasons, I want to stay in that. I'm not trying to beat you over the heads with the statute, but that's what we did. But I'm sorry, you know, you do what you learn. But in fairness to Mr. King, that's my job. But really, it's the fairness issue that I want you to focus on most. But the statute does also require that the lien be perfected within 12 months of the time it's due. And to my knowledge, that wasn't done. But please focus on the fact that the $2,000 was collected from Mr. Partridge, whose deed was of record, you know, no more than a matter of minutes. I don't know the time. I doubt that it was an hour. It was probably recorded very close to each other, and I think that one $2,000 collection was enough. There are also, I have to tell you, some kind of confusing accountings. Mr. King's received several accountings on this. The most recent one showed this $2,000 fee being imposed on January 1st of this year. And of course that couldn't be factually, because that's not when the transfer took place.
When was that transfer, sir?
It was recorded January 12 of 2007. The deed would have been dated January 10 of 2007.
January 10, 2007.
No, it was recorded on the 6th.
Oh, okay, I stand corrected then. It was dated the 12th and recorded
15th or 16th of January.
I don't have the copy of the deeds with me, I'm sorry.
So both of these transactions we're talking about occurred on the day 1/15/07.